Insurance brokers have always played an important role in the directors and officers' liability claims process. Today, that process is more important than ever. One of the brokers who has represented policyholders in such disputes is Norman Allen, Senior Managing Director of Carpenter Insurance Services, a NASDAQ OMX company. Norman, I'd like to begin by talking about the role of the broker in the D&O claims process. The Professional Liability Underwriting Society recently polled its members, and 75% of the respondents said that they do think that brokers play a positive role in the D&O claims process. Of course, that left 25% thinking otherwise, and apparently they had some comments as to why they think what they thought. I'm wondering, what lessons do you think could be drawn from the results of this survey?
I think the most interesting thing is that if you look at who filled out the survey, some 60% or so of the respondents are on the carrier side, either at a carrier or a law firm that works for a carrier. So despite those odds, 75% of the respondents still found that brokers were effective, which is good. It goes to show that even with a crowd that might not necessarily be broker friendly as its starting point, still looks favorably on that. As you say, 25% still said that brokers are ineffective. And when you drill into the comments on those, I think what you find is if somebody's had a bad experience, they come in negative and then they're willing to talk about it. Very few people made positive comments. They just checked yes and moved on. And in the negative comments, they were things like, standing in the way or being obstructionist. Ignorant was one of them. That was my favorite. And a few comments like that.
In the same PLUS survey, a vast majority of people said that it is insureds, not insurance companies, that initiate litigation over coverage issues. Is that your experience, and why is that the case?
Well, I mean, from a procedural point of view, if you will, what happens is the carrier writes, say, a letter and denies coverage, if that's the track they're going down, and then the burden kind of shifts to the policyholder to say, well, gosh, I think there should be coverage here. I'm going to go to court and try to make that happen. And so it's not a surprising statistic to me. I feel like when clients can't get something resolved, when it has not been effective, then that becomes their only sort of recourse to try to get payment from the carrier. The carrier can sort of sit back and wait and allow the policyholder to bring the fight first and then just respond to it.
D&O insurers have what they call litigation management guidelines. I wonder if you could help us understand what some of these are and whether from a policyholder perspective they're seen as reasonable.
Sure. Well, litigation management guidelines are quite common in all lines of insurance. They often come as a bit of a surprise to D&O buyers because it's never talked about in the process. If you read through a D&O policy, you're not going to find any reference to litigation management guidelines. There is reference to reasonable and necessary fees and costs of defense. And so the carriers use the litigation management guidelines as a way of enforcing that reasonableness standard. The problem is that unless the broker has raised it in the process and sensitized the client to the fact that they exist, they don't know they're there. And then a claim comes in. With D&O, there's often a sizable retention, especially for larger companies. And they could be a couple of years of defending a case before they actually get into the insurance. And if they submit the bills for the first time then, and those bills are subject to litigation management guidelines that no one knew about, then you have the potential for the carrier to say that some of the fees are not going to be paid. And that obviously is not a good outcome for the client.
Norman, what are some of the main reasons that insureds end up in coverage disputes? Are we talking definitions or other terms?
Well, I mean, you would think that it's the exclusions in the policy that would generally cause coverage to be knocked out, if you will. And that is true. Although if you look at the survey results, it's kind of interesting that of the top 3 areas that were identified by respondents where carriers have been able to not pay all of a claim, maybe they pay part of it but not all of it, 2 of those 3 were definitions, not exclusions. The definition of loss was one of them. The definition of claim was one of them. And then the third was the fraud and personal profit exclusion. So I think it shows in a way that the definition of claim is ostensibly an exclusion in the policy. The point is, of course, it is a contract, and all of the words in it matter. You need to focus on not just the exclusions, but also the definitions. And what brokers are doing in the D&O world all the time is working to broaden the policy, to make it more clear, to modify something like the definition of claim. And on that issue, where the real friction is today, is that D&O policies only come into play, they're only triggered when you get to the point of meeting the definition of claim. So something like an informal investigation, responding informally to an SEC inquiry, doing an internal investigation, et cetera, those are generally not covered by D&O because the definition of claim isn't broad enough to pick them up.
You mentioned in your last answer public companies, and I wondered if you could help us understand some of the differences in exposures that public companies and private companies face.
Sure. Well, for public companies, the D&O policy primarily is going to cover you for securities lawsuits. That's the biggest exposure by far. Shareholders bringing suits because they're aggrieved, they feel that something has happened to them that diminishes the value of their shareholdings. On the private company side, the vast majority of claims that hit D&O policies are employment practices claims, because a private company policy will pick that up, and usually that's the bigger exposure. Some private companies, if they have a fairly substantial shareholder base, or if they've been around for a long time and they've spun off their founders, et cetera, then you can get some suits on a shareholder sort of basis, but the vast majority of them are employment related.
Norman Allen of Carpenter Insurance Services, thanks for spending time with Insurance Journal.
My pleasure. Thank you.